Welcome back. Here we are in the second session. We still have three more colleges to go on. We have amongst ourselves now the Garnet House, represented by Children Welfare Center Law College, Malad West, Mumbai. They will be debating on the topic of Social Security Code 2020. You may start.
We all had proposed him unanimously as the Speaker of the House.
The permission has been granted for 0-hour discussion on Social Security Code 2020. You members can proceed.
Honorable Speaker, the Social Security Code 2020, meant to improve the quality of life and is a code of great importance. However, there are several defects to this code, which I, Ms. Ruhi, would like to raise in the 0 hour. Seeking permission from the Honorable Speaker to oppose the bill.
Granted.
Thank you. Let's begin with some statistics here. First and foremost, let's speak about digitization. 35% of the Indian population uses smartphones. But do we know how many of these are contract workers, gig workers, platform workers? Are they literate enough to use the Umang app or the eShram app, which is being promoted by the government for their benefits? No. 2% of the Indian rural population knows English. That's just 2%. Which means most of these apps which are in the English language are not available in vernacular languages. Thirdly, 58% of the Indian population are farmers. This bill also infringes the right to privacy. The right to privacy, which is a fundamental right for all the citizens of the country. When you link your Aadhaar, you share all your personal and your biometric information. A population of contract workers, gig workers, platform workers, not aware about the benefits given to them by the government, would be aware about Data Protection Act 2018? Answer is no. Second point, which has not been raised yet on the economics of scale of Social Security. US is the first country where the Social Security norms were unified. Mr. John F. Kennedy, the President of the United States, said, if we cannot serve the poor, we cannot serve the rich. Now, US population today is of 34 crores. Indian population stands at 140 crores. We are 5 times the population of the United States. The United States reserves of Social Security are going to deplete by 2034. Do we have, and this is a Bloomberg report, do we have any such report for the Indian economy? No. But I do have some statistics to share with you. In the EPFO, 24.77 crores are the accounts which we have. However, as per the Economic Times report in March 22, over 23 lakh pensions were drawing rupees 1,000 per month, even when their contributions to the fund corpus has been less than a fourth of the benefits they were drawing. Which leads us to the fact that we do not have a clear direction and understanding of the economic scale rendered for the purpose of Social Security. Coming to the maternity benefit, again some statistics. 140 crore population growing at 1% each year, surpassing China by 2025. 970 females for every 1,000 males, which means around 3 crores, because the Maternity Benefit Act states that we cannot extend it to more than 10 or more workers. Around 3 crores women who can be childbearing will not be able to avail this benefit. Lastly, a food for thought on this particular debate. Something which has been said by the US representative, Mr. Hank Johnson, which I totally believe in. Social Security is not just another government spending program. It is a promise from our generation to the next. Anyone who wants to oppose this?
Anyone wants to oppose?
No.
Proceed. Who is in favor?
Honorable Speaker, with your permission, may I commence?
Before speaking, state your name.
I am presenting Garnet House for the for side.
Okay, proceed.
The Code on Social Security 2020 was introduced in the Lok Sabha by the Minister of State for Labour, Mr. Santosh Gangwar. You know what is the benefit part of this? It was the bill which was taken up in the junior house on the 19th, followed by the very second day to the upper house, and in the 3 days it got actioned up. So that was the beneficial part. But what exactly the inroads come out? The social security schemes, the central government notified that the schemes for the benefit of workers, and it has unanimously taken up with the merger of the previous 9 codes. In that has benefit to the lower scale ground to the top bottom. That's how we take it forward. The social security organizations working on the scheme has grassrooted up the minute points to the major points. The minute points, if I enlight, that is a gratuity benefit for the regular person who works anywhere in any sector. Do you know in the previous hours, the gratuity was only given on the 2 benefits, but now after this code would be commenced, it will be applied on the several others too. So that was just a one part which is saying the positive side of this bill. Let me take you through the implantation over here. Here, the coverage and registration which has been taken to the lower sector. What I mean by lower sector? The people, those who are working in the unskilled industry, unorganized industry, that are being also listed over here. By how? That the question will be aroused. That is by the platforms which are electronically working on the various scales. You have been seeing that the past 7 to 8 years, our government is working to digitalize the various things which were never on the board. So with the help of eShram card, till the date, we have acquired 27 crore of data of the laborers in this sector, which was more than the 50%. The total recorded data would be 50 crore, that will be coming soon. Here, the benefits given to each and everyone who are working together, that is not only to the employee, but to the employers also. Let me tell you, what are the offenses and the penalties? Have you heard about it, the offenses and penalties previously to the employer? It was not never coded beyond, but it is today. That is starting arousing from 50,000 penalties to the 2 lakhs, because these benefits need to be given on the grassroots, on ground. That was the major pointers we put up. There were the convergence where there was no such benefits given to the lower house. Why that's so? You know, platform workers, the people, those who work unanimously on ground by helping each and everyone, but they never got a support up. Who are the platform workers? Let's know about it. The people, those who works with various brands and others on a time-to-time base, like today we can see a person who is delivering us a food, he is a platform worker. Who is he? A Zomato deliver person. But when you see, there is a taxi driver who is coming into all the 3 categories which are formed in Social Security Code. That is a platform worker too, working with some other brand. Working on the gig worker side, he is a gig worker too, another. So that's how a one person has been garnished up in the 3 benefits up. But what are the benefits? That will be holded up by our session as we move ahead. So let me tell you that all this is going to leading with the positive side. But how? The question aroused here is, but how? Do you know the first country to brought up the Social Security bill was the US? And the best impact, when the pandemic, we all were hampered with the job losses and more. That time, the US government had given ample of benefits to their citizens who are enrolled under the Social Security scheme. You know, there is an economy which we have, although we know what is economy over here. So, what is the count of economy? In India, it's 3 trillion economy. So it's never a load on the social scheme when we implement it too for our citizens. The population is arousing in our country. That's 100% right. But again, we are developing people, those who are going in the next generation to the one bottom. What exactly the reformation we thinking after the social security would be a gift given from one generation to the second generation, and that will be the real benefit which will be seen on ground very soon. With this, I conclude my point on the pros side of Social Security Code. Thank you.
Honorable Speaker, I would like to draw your attention towards the Social Security Code 2020, which consolidated 9 laws into the 4. Number 1 is Code of Wages 2019, that was passed in the Lok Sabha on 30th July 2019. In the Rajya Sabha, it was passed on 2nd August 2019. President assent was given on 8th August 2019. But the implementation was not done, hence it was circulated on 7th July 2020 for comments, which includes Payment of Wages Act 1936, Minimum Wages Act 1948, Payment of Bonus Act 1965, Equal Remuneration Act 1976. Second, Occupational Safety, Health and Working Conditions Code. This was introduced in Lok Sabha on 23rd July 2019 and was referred to the Standing Committee on 9th October 2019. Now it was further delayed and hence report Standing Committee has given for waiting. In this, there are certain limitations, which states as different limits for different states. Appeal can be done only in High Court and not in Civil Court. For this, any employee or employer will be aggrieved in order to file the complaints. This court bars Civil Court from hearing matters. Number 3 is Codes on Industrial Relations, which subsumes as the Trade Union Act, the Industrial Employment, Industrial Disputes Act. It was introduced in Lok Sabha on 28 November 2019 and referred to the Standing Committee on 23rd December 2019. A report was asked to be submitted in 3 months, but it was not received and extended till 23rd of March. First time in the history, it has been reported that government has the power to change the industrial tribunals and it has to be modified or rejected or delayed. For the first time, it has been given that above judiciary, the power has been given to the government. Fourth code is Code on Social Security, Provident Fund Act 1952, Maternity Benefit Act 1961, Unorganized Workers Social Security Act 2008. It was introduced in Lok Sabha on December 11, 2019. It was referred to the Standing Committee on 23rd of December 2019. Standing Committee report. In 3 months it was asked to be submitted, but still it was further delayed till monsoon session. Major changes that was done in this code was EPF and NPS was not included in this bill, and the PF and ESI should be merged and made corporate body, but it wasn't done. Social Security Code again defines gig workers under Section 2 subclause 35. Section 2 subclause 61 defines a platform worker. Now again, over here, it states that they don't have predictable wages and a steady relationship, no predictable future progress in career, have to cope up with emotional disturbances and income with ups and downs. Large section of gig workers had no form of social security, example, health. Now, if a beauty parlor owner works as an
Member,
online
you have
worker-
exceeded your time. Please conclude yourself.
Okay. Last thing I would like to say, in section 114, central government states that the word may has been used. Instead of the word may, it should be used as shall, because the government is showing as if they are doing a favor. It should not be done as a favor, it should be acted like as a right. Thank you.
Honorable Speaker, seeking your permission to speak in the favor of Social Security Code 2020.
Granted.
I am representing the Garnet House. First and foremost, let me thank you for giving me this opportunity. As my dear friend stated, just going to complete the mentioning, I'm not objecting you, but I'm telling you, it is clearly mentioned in the section, the home-based workers and the entrepreneurs. The home-based workers are the beauticians who are based in home, are also prevailing this scheme. In different sections, actually Social Security Code covers widen up the category of labor, and the labors are who? The labors are house-based workers, entrepreneurs, platform workers, aggregators, that is digital intermediates, and self-employed, the entrepreneurs, which I have said. Gig workers, you said, had no eligibility, but yes, you're wrong. Again, gig workers have now become eligible for life and disability coverage and maternity benefits and pensions, which was not previously done. Let me also highlight you with this. This code only doesn't cover the benefits for gig workers and platform workers, also interstate migrant workers, which was a big question mark previously. In addition to this, this covers the questions on contract employers, which had no provision further prior to this. And who funds this? The state and central government funds this through CSS. What are the provisions given in this? Provisions are given as penal provision. If there is a failure in paying of gratitude, there is a penal provision provided over here. What else does this provision, the code provide you? It provides you discouraging the inappropriate structure of salary. That is, brings a uniformity in salary. There is a uniform salary basis. Beside this, as you said, Aadhaar linking is made mandatory. Yes, Aadhaar linking is mandatory because it again brings the uniformity in the whole nation. As mentioned in Puttaswamy case, you had mentioned that Puttaswamy case mentioned mandatory Aadhaar linking is not necessary. But it is also said in that same judgment, Aadhaar card number may be made mandatory for the expenditure and subsidies and beneficial schemes by the government. So it clearly states all what is mentioned in the scheme and covering the most terms from employer to employee. I would like to say by a state and a quote by Martin Luther, all labor that uplifts humanity and dignity and importance should be undertaken with painstaking excellence. This simply means a nation whose backbone is a labor should be given its respect, importance, and should be dignified. I would conclude only by saying this code is a right step and a positive step for the worker class people. As every law takes some time, we should be patient and see how this will come back to us. Thank you.
How would you differentiate between a gig worker and a platform worker? Number two, my question to you is, how would you define that Supreme Court is making mandatory about the Aadhaar card? If Supreme Court is making mandatory Aadhaar card, how would you go on the basis that it is not violating Puttaswamy's 2's judgment?
Sir, I would like to tell, in Puttaswamy's same case, the rule has been mentioned that Aadhaar card in any beneficial scheme of government is mandatory. That is written in the provision. And secondly, gig workers and platform workers have a proper provision and section defined in the scheme. Gig workers, the freelancers, have their own provision for pension, gratitude, maternity, which was not there prior.
But both of them are coming into the online workers.
No. Platform workers are working on hourly basis on e-commerce also. But gig workers are not so. They are your local workers which work for day and night for their bread. That will be your Ola, Uber, and so on.
But if the same person is having a beauty parlor owner and if she's working for an online platform, how would you differentiate?
This is also clearly mentioned. This criteria is mentioned for entrepreneurs and that is self-employed person and home-based employed person. Home-based person are coming in this. Actually, this provision covers most of the occupational laborers.
Honorable Speaker, seeking your permission to speak against the Social Security Code 2020.
Granted.
The primary aim of the Social Security Code was to assimilate and amalgamate the existing laws to provide effective ease to the industries and businesses. However, it merely consolidates the existing law by providing separate chapters to the separate social benefits. Next critical point would be that state being appropriate government for formulation of schemes to informal sector, it would lead to multiplicity of the law, that defecting the very purpose for which the code is enacted, that is consolidation of the law. Next defect I would like to draw the attention is regarding to the gratuity. Due to the very fact that most of the workers are employed for shorter period, it is difficult for them to avail the gratuity benefit as the prerequisite for the same is 5-year employment. And similarly, the gratuity benefit is not extended to the contract laborers and the time rate workers. Why this limitation is provided in the law? Next mistake I would specify is related to maternity benefit. Chapter 6 speaks about maternity benefit. Maternity benefit is not made universal. It is applicable only to the establishments which has 10 or more workers. And the term establishment does not include unorganized sector. Why? But is this only mere that the law includes the unorganized sector, or it really includes the unorganized sector? Next fault is with regard to Building and Construction Workers Act and their compliances. The Act provides for registration of construction workers, but it does not mandate the same, that it would be worker or the contractor responsibility to register the building workers, because it would be foolishness to accept that the building worker he himself has the digital knowledge and will register himself. Next, I would like to conclude that in India, 91% of Indian workforce are not given social security with this code. Even today, informal sector workers face difficulties due to registration barrier, lack of awareness, lack of proper documents, and so on. And these difficulties are not overcome with the proposed law. I would like to inform the opposition, the governing party, to specify more improvement in the law before implementing it. Thank you.
Honorable Speaker, I am glad to represent my house, Garnet, and to address this code for the Social Security 2020. Previously, there are different labor acts, so we amended and consolidated all those different labor acts into the one code, which is known as Code for Social Security. This code is going to upgrade the standard of living of the workers and to provide them the equal opportunity irrespective of organized and unorganized sectors. We mainly focus on 4 main codes. First, wages. Second, social security. Third, industrial relationship. And the fourth one is occupational safety, health and working environment. We also added some terms like gig workers, section 2, subclause 35. Gig workers are those workers who work for part-time, which don't have any traditional relation between the employers and employee. Second term is platform workers. Platform workers are those workers who works on e-sites like Amazon, Swiggy, Zomato, etc. It is in section 2, subclause 55. Another definition is of unorganized workers. Unorganized workers are those workers who are self-independent, and this term is so important for the benefits of the laborers and workers. We also widen the term of employee so that we can include a large number of employees in this code. Previously, in different act, there are different definition of wages. So, in this act, we combine a specific definition of wages. This code not only going to provide the social security, but also going to provide the income security and the healthcare access to the workers in the case of old age, unemployment, sickness, work injury, and maternity, and so on. This code is going to give the benefit to the unorganized sector workers, gig workers, platform workers, benefit in EPF, Employee Provident Fund schemes, benefit in ESI, Employee State Insurance schemes, and benefit in maternity for the women. At last, I just want to conclude that to the opposition party, that before criticizing this code, just think once that this code is going for the welfare and the benefit of the labor and to give them the equal opportunity which has been given to the government sector employees and to the private sector employees. This code is for the welfare and to protect the interests of the workers of our country.
We are not criticizing, but rules are rules. Rules are made for everybody.
Honorable Speaker, seeking permission of the Chair to speak, I would like to present favor of Employee Provident Fund, Section 144 in the Code of Social Security 2020 under Chapter 3 and 4. So, any employee of India receive the salary. After employer deduct the certain amount of money, so Provident Fund, one might feel that they are not able to spend their cash in hand. However, when person wants to retire from their job, the employee provident fund is one of the main contribution help for their living. EPF scheme is long-term retirement savings scheme managed by EPF organizations. Social Security Code 2020 altered the applicability of Employee Provident Fund scheme, which will now be applicable to every establishment in which 20 or more employee or employed. Central government may be purpose of provident fund scheme establish PF where the contribution paid by employer to fund shall be 10% wages payable to each employee. Pension scheme sums payable to contributions 8.33%. Pension fund not exceeding to wages. There is a contributions of employer and employee. Employee is at 12% and employee is at 12% of pension fund. Government of India will pay EPF contributions of both employer and employee 12% of not 3 month for that nobody suffer due to loss continuity of the EPF organizations. Those establishments have up to 100 employees and 90% of whom earn under 15,000 monthly wages. This benefit about 80 lakh employees and incentivize of about 4 lakh establishments. Here is the benefits of Employee Provident Fund. Employee Provident Funds offers the multitude of benefits those who alive. Employee Provident Fund is
Member,
one of
please
the
conclude
most,
yourself. You have exceeded the time.
Yeah, here is the conclude. Here is the concluded. Employee Provident Fund is excellent saving scheme of building sufficient retirement corpus of salary employed over the career time, one shift job multiple times.
Honorable Speaker, seeking the permission of the Chair to speak against the Employee Provident Fund scheme
Granted.
covered under Chapter 3 of the Social Security Code 2020. Before the Social Security Code 2020, the law which governed the Employee Provident Fund scheme was the Employee Provident Fund Organization Act 1952. However, the benefit of this act were limited to the organized sector. The new act is enacted by the government to include under its ambit the organized sector of the working class. However, a deeper inquiry of the provisions of this act proves that the promises made by the government, as always, are nothing but empty. So why do I say so? Firstly, the workers of the unorganized sector are not expressly covered under the provisions of the EPF scheme under Chapter 3. Instead, the government has given to the working class a toothless tiger. Now, what is this toothless tiger? This is the Social Security Board, which has been constituted under Section 6 of the Social Security Act 2020. The functions of this Social Security Board are mere recommendatory in nature and are not binding upon the central government. Hence, at the end of the day, the working class and the unorganized worker is left with nothing but hollow promises. Furthermore, adding insult to injury is Section 143 of the Social Security Act, Social Security Act 2020. In this act, the government reserves the right to exempt any Honorable Speaker, any establishment from the ambit of this scheme. In this procedure, the most vulnerable stakeholder in this whole decision-making process, which is the employee, is exempted and not asked about his opinion. The employee of the unorganized sector worker is at the end of the day at the mercy of the benevolence of the big brother government and the big business houses. And for what? For what, I ask Honorable Speaker, a morsel of his very own hard-earned money. Finally, I would like to conclude by saying that the workers of this country and the world are not naive. They will look through the hollow catchphrases and promises of this ruling government. And I would like to make the ruling government aware of the fact that unlike them, the workers of this country and the world have nothing to lose but their chains. They have a world to win.
So I would like to bring up the same section is mentioned over here, providing that the salary allowances and the benefits given shall be specified in the clause and shall not exceed the pay, respectively, provided in the provision for. It is already specified in this.
But what about the PF and the ESI, which is not included?
Honorable Speaker, seeking permission of the Chair to speak in the favor of employee state insurance, which is covered under Social Security Code 2020 under Chapter 4.
Permission granted.
So to understand this, let's go to the history of ESIC Act 1948. Referring to the old act, this bill introduced by BP Adarkar for the welfare of low wages employees. This bill passed through several amendments. In Amendment 5A, replaced by new 5A 2010, which speaks that the employee's family member is also covered in ESIC. So what is ESIC? ESIC is an insurance company run by Government of India for the employee whose per month wage is less than 21,000. This insurance company not only covers medical insurance, it also covers sickness, maternity, death, disablement and unemployment. Referring to the old act, employees who is covered under this act are all shops, establishment, factories, and now unorganized sector workers and gig workers are added. Not only employer will also get benefit, which is work-related accident disablement. Now let's look at some statistics that contribute before 2019. Was 6.5%, from which employee will have to pay 1.75% and employer will pay 4.75%. Now let's look at some positive changes in ESIC under Social Security Code 2020. Contribution rate, which was previously 6.5%, is decreased to 4%, from which employee will have to pay only 0.75% of his monthly wage. This change has done when is much needed. First. Second, unorganized sector and gig workers will now be covered in ESIC under Social Security Bill 2020. Second, if a single employee employed in hazardous or life-threatening work, then also he will be covered under this act. As they work under extreme dangerous condition, this provision is much needed for these employees. If any employer fail to pay the contribution of employee, the employer is bound to provide benefit to employee if needed. Further, recovery will be covered from the employer by ESIC, so it's next to impossible to employer to do these types of frauds. This bill specifically aims to low-income group workers whose per month wage is less than 21,000. For those whose salary is more than 21,000 will be covered under general insurance. I would like to conclude by saying, in this country where these workers are neglected, this social security bill where ESIC is covered is a big opportunity to workers to get better working and retirement life. We should see in positive way that government is giving better life with minimum amount. Thank you.
Just wanting to know, these benefits are being availed. What is the data that you have? Just trying to understand. E-Shram app is 27 crore people who have downloaded the app. But how many is the number of people who are availing the benefit of it? Can anybody provide that statistic to us?
With the exact data, I may say 27 crore for the download ratio as per you. The active IDs of E-Shram in the today's generation is more than 150 million.
Why the PF and ESI was not merged and made as a corporate body? Number two, why EPF and NPS was not included in this bill?
Honorable Speaker, seeking permission to speak against the provision of the Social Security Code covered under Chapter 4 relating to Employee State Insurance Act 1948.
Permission granted.
Thank you, sir. I am a participant of a Garnet House, and my areas which is fulfilling my requirements are as follows. My four major criticisms on these codes are as follows. The first criticism is the Employee State Insurance Code scheme currently does not cover workers or employees who are earning more than 21,000 per month. And in the case of persons with a disability, the maximum wage is capped at rupees 25,000 per month, which is also a negative part. And my second criticism is the existing wage limit for coverage under the Act effective from 1st January 2017 is rupees 21,000 per month and rupees 25,000 per month in the case of persons who are disabled. And my third criticism is ESI is the premium paid for medical benefits. If no benefits is obtained from it, there is no option available for the workers. And my fourth criticism is it is not applicable in the states like Mizoram, Arunachal Pradesh, Manipur, Nagaland, Tripura and Sikkim. This is also a negative part. So I would like to conclude on my topic that is the ESI scheme will apply to certain establishments with 10 or more employees, and what about the people working in hazardous or life-threatening work? This is the complete threshold to the previous ESI scheme. Thank you.
My learned friend, this has been covered in the part of gig workers. Kindly pay attention.
My question again to you is, why interstate migrants whose earnings are termed as rupees 18,000 per month, only they are termed as interstate migrants? Why?
Honorable Speaker, seeking permission of the Chair to speak for the favor of this code.
Permission has been granted.
One of the 9 laws that subsumes is the Payment of Gratuity Act in this code, which is the major retirement benefit for the employees in India. And in accordance to Section 2, subsection 7, applies to all organizations with more than 10 employees, including unorganized workers, that is MNCs, schools, and other companies. Because employees sacrifice the prime moments of their lives for the development, prosperity, and betterment of their employers. An employer pays his employee gratuity as a graciousness or a gift. Gratuity is a statutory obligation of the employer to promptly tip their employees when there is due. Previously, under Section 4, subsection 2 of the Payment of Gratuity Act 1972, gratuity was applicable to only employees who had worked in the company for 5 consecutive years based on their 15 days salary for full year. In the event of death, disability, etc., it can deviate from the 5-year rule. But under Section 53, subsection 1 of this code, the mandatory minimum 5-year gratuity was abolished in the bill of the Social Security Code. But different threshold structures were introduced for various categories of employees. The perquisites of this is that the regular and the permanent employees must have worked for at least 5 years to be eligible, although no such restriction applies to employees with fixed-term contracts. Overall, the enactment of the Code on Social Security 2020 is a welcome step. It is easier to understand the scope and the ambit of the Social Security law by consolidating the pre-existing laws. As this code is for labor and for middle class people, I would like to share my 4 lines on them. खर्चे में बरकत नहीं बरगद का पेड़ है, पतझड़ के मौसम पॉकेट में छेद है, कर्जे 2.5 और खर्चे 1.5 है, बिजली विभाग ने भी जंग दी छेड़ है, मिडल ही सही पर हमारे पास क्लास तो है, रिटायरमेंट नज़दीक पर ग्रेचुटी की आस तो है, feeling gratitude and not expressing it is like wrapping a present and not giving it. Thank you.
My question again to my dear friend is, Code on Occupational Safety, Health and Working Conditions on 2020 states that as per the Central Government Act Section 14 states that 2020 bill removes displacement allowances. Why?
I have another question. We'd be paying 1,000 rupees per month, 1,500 rupees per month, 2,000 rupees per month as pension to pensioners. With the rate of inflation which we are going with, is this money enough? Is this a joke which we are paying 1,000 rupees per month or 1,500 rupees per month?
Ma'am, Ma'am, we are not covering all the employees over here. We are covering the employees who are working for more than 5 years that have been loyal to the company. So we are having a proper funding and statistic to cover this.
Exactly, but the quality of life does not come at 1,000 rupees.
I know the information
There's
will
no
be
standard of
increasing,
living at 1,000
but
rupees.
India is a developing country with the entrepreneurs and the progress. Everything in the point of view, the scheme has been up. The statistics have been looked forward for coming years.
But then the rate of inflation needs to come in control. What about the rate of inflation?
It's a real shame. Shame.
Your heckling is not permissible. Please proceed.
Don't worry, my learned friend. We are a big economy running country, having a great population with it, going with 2,000 billion of the e-funds.
So what do you mean to say? What about the inflation?
India is growing effectively. We have the people, those who are working in that. And I may tell you, there are the people, those who are learning, and the ratio of people who are skilled is more than some other countries. Thank
What
you.
about the unskilled people? What about the unskilled people, workers?
They are the backbone of my nation.
Please maintain the dignity.
What about the inflation rate? You're counting on 1,500, 2,000. What about that?
Please stand and say.
What about the 1,500 and 2,000? What do you mean to say that by 1,500 a worker can run his family?
Your statistics are a little wrong. There are the schemes which are run under the ration card also. Please
There are
correct it.
schemes, but what about do you think these schemes are available to a common man?
Kindly correct your knowledge. Please go on ground and check which schemes are on and not. Today, in the 2022, I may say there are 22 active schemes for the benefit of the people. That is, you also run Ujjwala scheme as an example to you.
That's the reason the statistics, we need the statistics as to how much is it a strain on the economy when you're paying the pensioners 1,000 rupees per month and we are growing at a rate of inflation at 6% per year.
With your honest permission, may I comment?
Proceed.
Yes, I very much agree with my friend. But there are some points to criticize. First of all, what is gratuity? Gratuity is a monetary amount which is payable to the employee of an organization under the Payment of Gratuity Act 1972. This is mainly paid to the employee as the token of appreciation for his or her services towards the organization. As per section 53, subsection 1 of the Payment of Gratuity Act, they should be eligible for superannuation. If the employee is not eligible for superannuation, they are not eligible for gratuity. This is the most important point of criticism. The second point of criticism is that the employee should resign after the continued service of 5 years with the single employer. Means if the employee works for less than 5 years, he will not be eligible for gratuities. The third point to criticize is that the employee should be a fixed employee of the organization. That means if he is on a contractual basis, he is not eligible for gratuity. And the fourth point and the foremost point of mine to criticize is that the employing more than 10 employees are only eligible for gratuity. My suggestion to the respective council is that the limit of 10 employees should be reduced to at least 2 or 5. Thank you. Jai Hind.
As my friend said, to reduce the tenure from 5 years to 3 years, we have already reduced it for working journalists. And as you are saying that it should be reduced, gratuity is a it's an loyalty reward, and it's not like a pension fund. It's a loyalty reward. You will have to prove your loyalty, then you will be getting gratuity.
Was it number of workers or the tenure, which my friend said here? No.
He said the number of workers.
Please stand and speak. You want to speak? Then stand.
Respected friends, kindly pay attention to your speaker's learning. Thank you.
Number of workers.
I said, I repeat, there should be a number of workers, which should be reduced to at least 3 or at least 5. Thank you.
Honorable Speaker, seeking permission of the chair to speak in support of the Maternity Benefit Act.
Granted.
Being a woman, I feel immensely proud and honored to be able to voice my opinions and convey them between so many people. Comprising nearly half of the population, women make up a crucial chunk of the workforce of our nation. Employment demands the need to manage work and child responsibilities together, which is not an easy task. As a nation where the bond between the mother and a child is considered sacred, as a nation where the love and bonding between families is given utmost importance and respect, in such a nation, why is that the plight of working mothers is often unheard? Why can't we, as a nation with such a big economy, help such mothers? The provisions under this code will not only hear but also help those working mothers. And this is one of the reasons why I support this bill with an eager and an hopeful heart. The framework of the Indian Constitution endeavors to provide women equality in all walks of the life. Article 42 of the Constitution mandates the responsibility on the state to provide women with a Maternity Benefit Act along with fair conditions of work. In furtherance of this pursuit, the Social Security Code of 2020 under Chapter 6 aims to grant maternity protection to women in order to ensure active participation in economic activities post-maternity without any hindrance. Now I am going to be stating some of the benefits of these provisions. Did you know that the World Health Organization recommends mother to exclusively breastfeed a child for 6 months after birth to decrease the number of infant mortality rate? This code will not only positively impact the child's health, but also decrease infant mortality rate along with maternal mortality rate. The code additionally permits employers to allow their female employees to work from home along with the maternity leave that they are going to get. This will immensely help women who are going to be working in the IT sector, who are design professionals, software developers, to name a few professions. Are you aware of the fact that only 29% of the women actively participate in the organized sector? These provisions will help approximately 1.8 million women in the organized sector. It will also help
You are
India-
exceeding your time.
Sorry.
Please conclude.
There is an urgent need for maternity benefit so that a woman is able to give love and attention to her child without having to worry about losing her job. A woman should never be put in a position where she has to choose between her child or her job, at least not in the 20th century. After analyzing the various provisions under the maternity benefit which is given in this code, I would say that this code would be a boon for the working woman. And I would conclude this by saying that a step towards development is always better and more appreciated than no step toward development at all.
But then less than 10 women, then less than 10 workers should not be bearing children, right? Organizations where there are less than 10 or 10 women working should not be bearing children because they cannot avail this benefit.
For this, I would say that this benefit, if this code will benefit only a little amount of women, that is also good, because earlier no one was benefiting. No one was actually benefiting from any code. A step towards the future is always better than no step at all.
माननीय सभापती महोदय, तुमची मान्यता असेल तर मी माझे विचार मांडण्याचा प्रयत्न करेन.
Proceed.
बांधकाम कामगारांवर भाष्य करताना मी सांगू इच्छिते केंद्रीय कामगार व रोजगार मंत्रालयाने सामाजिक सुरक्षा संहिता 2020 याचा मसुदा अधिनियम जाहीर करण्यात आला. अधिनियम 8 अंतर्गत बांधकाम कामगारांना सुरक्षा प्रदान करण्यात आली आहे. आता स्थलांतरित मजूर, असंघटित क्षेत्रात काम करणारे सर्व प्रकारचे कामगार यांना या कायद्याच्या कक्षेत आणण्यात आलं आहे. मी या संहितेमध्ये बांधकाम कामगारांविषयी असणाऱ्या योजनेंवरती प्रकाश टाकण्याचा प्रयत्न करेन. पहिल्या विवाहाच्या खर्चाच्या प्रतिपूर्तीसाठी रुपये 30,000ची मदत इथे केली जात आहे. मध्यान्ह भोजनावरती याआधी जास्त प्रकाश टाकण्यात नव्हता आला, तो आता इथे टाकण्यात आलेला आहे. प्रधानमंत्री श्रमयोगी मानधन योजना, प्रधानमंत्री जीवन ज्योती विमा योजना, प्रधानमंत्री सुरक्षा विमा योजना, पूर्व शिक्षण ओळख प्रशिक्षण योजना, पहिल्या दोन मुलांसाठी ज्या योजना आहेत त्यावरती आता मी प्रकाश टाकेन. सभापती महोदय, इयत्ता 10वी व 12वी मध्ये किमान 50% किंवा अधिक गुण प्राप्त झाल्यास रुपये 10,000ची मदत या संहितेनुसार केली जाते. पदवी अभ्यासक्रमाकरिता प्रतिवर्ष 20,000ची मदत या संहितेनुसार कामगारांच्या मुलांना केली जाते. या संहितेमध्ये नोंदणीत कामगारांच्या कुटुंबियांचा देखील ते सहभाग केलेला आहे. वैद्यकीय पदवीकरिता प्रतिवर्षी 1 लाखाची मदत, अभियांत्रिकी पदवीकरिता प्रतिवर्षी 60,000ची मदत आणि त्या कामगाराच्या पत्नीसह लागू होते. शासन मान्य पदविकेसाठी प्रति शैक्षणिक वर्षी 20,000ची मदत इथे या संहितेद्वारे केली जाते. शासन मान्य पदव्युत्तर पदविकेसाठी प्रति शैक्षणिक वर्ष 25,000ची मदत या संहितेनुसार केली जाते.
प्लीज कन्क्लूड. टाइम इज एक्सिडिंग.
येस. एका मुलीच्या जन्मानंतर कुटुंब नियोजनाची शस्त्रक्रिया केल्यास त्या मुलीच्या नावे 18 वर्षापर्यंत 1 लाखाची मुदतबंद ठेव ही संहिता देते. याआधी असं झालेलं नव्हतं. या कामगारांच्या कामावर असताना मृत्यू झाल्यास 5 लाखांची मदत कायदेशीर वारसदारास केली जाते. कामगाराचा मृत्यू झाल्यास देखील अंत्यविधीसाठी 10,000ची मदत ही संहिता देते. याहून जास्त योजना आपल्याला ही संहिता देते. म्हणजेच मला असं वाटतं की काहीच नसण्यापेक्षा काहीतरी असणं ही मोठी गोष्ट आहे. या योजनांपर्यंत पोहोचण्यासाठी योग्य त्या सांकेतिक स्थळावरती आपण जाऊन नोंद करतो. आता काही जण म्हणतील की आपले कामगार हे अशिक्षित आहेत. मी सरकारला एवढी शिफारस करू शकते की आपण फक्त या नोंदणीसाठी एक सरकारी अधिकारी नेमावात. आणि मला वाटतं खरंच सांकेतिक स्थळावरती आपण जर भेट देऊ तर मला वाटतं सगळ्यात जास्त कमी वेळात आपण योग्य त्या बांधकाम कामगारापर्यंत पोहोचू शकतो. म्हणजेच कामगारांच्या मृत्यूनंतर देखील त्यांच्या कुटुंबियांना ही संहिता बळ देते, अभिमानाने जगण्याचा अधिकार देते. शेवटी मी एवढंच म्हणेन सभापती महोदय, मी सभागृहाचा जास्त वेळ घेत नाही. मी शेवटी एवढंच म्हणेन, तू जिवंत ठेवतोस कामाचे आगार, उभारतो स्वप्नांचे मिनार, बांधकाम कामगार तुझ्या कष्टाला सलाम. मी असं समजते की सामाजिक सुरक्षा संहिता 2020 याला मी योग्य तो न्याय देण्याचा प्रयत्न केलाय आणि इथेच थांबते. धन्यवाद.
हेलो. कुर्सी पर विराजमान अध्यक्ष महोदय, यहाँ पर उपस्थित मेरे साथी और संगी और मान्यवर, आप सभी को मेरा सादर नमस्कार. हम जिस विषय पर यहाँ पर चर्चा करने जा रहे हैं वो है सामाजिक सुरक्षा विधेयक 2020. सामाजिक सुरक्षा विधेयक 2020 के अंतर्गत निर्माण कार्य करने वाले मजदूरों के साथ जो नाइंसाफ़ी इस कानून में की गई है उसके बारे में हम यहाँ पर चर्चा करने जा रहे हैं. सबसे पहले तो थोड़ा सा परिचय इस सामाजिक सुरक्षा विधेयक जो है इसके बारे में बता दें। सामाजिक सुरक्षा विधेयक ये 22 सितंबर 2020 को लोकसभा में पारित हुआ और उसके दूसरे ही दिन यानी 23 सितंबर 2020 को राज्यसभा में भी पारित हो गया। 5 दिन के बाद 28 सितंबर 2020 को ये महामहिम राष्ट्रपति जी के पास लाया गया और उसी दिन इस पर हस्ताक्षर होकर राष्ट्रपति जी ने अपनी मोहर लगा दी। तो मैं ये पूछना चाहता हूँ कि आनन फानन में इतनी जल्दबाजी क्यों की गई इस विधेयक के ऊपर? क्या विपक्ष को विचार विमर्श के लिए इसमें शामिल किया गया, उनसे राय शुमारी ली गई? नहीं। तो जब उनसे राय शुमारी नहीं ली गई और आनन फानन में जल्दबाजी में ये विधेयक पे पास किया गया, इसे लाया गया, तो यानी इसमें कुछ गड़बड़ है। अब इस विधेयक के अंदर जो कानून आते हैं, जैसे निर्माण कार्य करने वाले हमारे मजदूर आप जानते हो भारत देश में 2 तबके के लोग सबसे ज़्यादा रहते हैं, एक हमारे किसान भाई और एक हमारे मजदूर भाई। किसान जो भारत देश के रीढ़ की हड्डी है और ये जो मजदूर हैं ये हमारे देश के बाजू है, तो हम इन्हें कमज़ोर कैसे कर सकते हैं? हमें तो ऐसे कानून लाने चाहिए कि सारे मजदूरों उसमें समा जाए और उसमें आ जाएं। इस कानून में जो कमियां हैं उसके बारे में मैं ज़रूर यहाँ पर बताना चाहूँगा कि इस कानून में क्या क्या कमियां हैं। सबसे पहली कमी तो यही है कि जहाँ पर 10 मजदूर से कम लोग काम करते हैं, यानी 8 मजदूर हैं, 9 मजदूर हैं, 7 मजदूर हैं, उनको इस कानून के तहत लाया ही नहीं गया। उनके साथ यह नाइंसाफ़ी क्यों? उन्हें भी तो अधिकार है इस कानून के दायरे में आने के लिए। दूसरी बात, जो मजदूर कारखानों में काम करते हैं, खदानों में काम करते हैं, उनको भी इस विधेयक के, इस कानून के अंदर नहीं लाया गया। उनका भी क्या दोष है? उन्हें भी तो लाना चाहिए। वो भी तो हमारे देश के नागरिक है, वो भी तो हमारे देश के मजदूर है, उन्हें भी इस कानून के अंतर्गत लाना चाहिए। तीसरी बात, यहाँ पर 2 सरकारें हैं, राज्य सरकार, केंद्र सरकार। अब इसमें असमंजस ये है कि मजदूर कहाँ पर जाए, राज्य सरकार के पास या केंद्र सरकार के पास? कोई भी जिम्मेदारी लेने को इसमें बाध्य नहीं हो रहा है। चौथी बात, मजदूर जो है वो अलग अलग प्रांतों से आता है, अलग अलग राज्यों से आता है, आंध्र प्रदेश से आता है, यूपी से आता है, बिहार से आता है, बंगाल से आता है।
प्लीज कंक्लूड योरसेल्फ।
उनके लिए क्या प्रावधान है? वो वहाँ पर रजिस्टर्ड है। वो महाराष्ट्र में अगर जो आते हैं काम करने के लिए, तो यहाँ भी उन्हें रजिस्टर्ड करना पड़ेगा, यहाँ भी पंजीकृत करना पड़ेगा।
प्लीज कंक्लूड योरसेल्फ।
और सबसे बड़ी बात तो इसमें यह है कि आज 2 साल बीत चुके हैं। 2 साल बीतने के बाद भी ये विधेयक नोटिफाई नहीं किया गया है, इसे नोटिफाई नहीं करा पाए। 2 साल बीतने के बाद भी ये नोटिफाई नहीं हुआ।
प्लीज कंक्लूड योरसेल्फ, टाइम इज ऑलरेडी एक्सीडेड।
इन्हीं कमियों के साथ मैं 4 लाइनें जो हमारे मजदूर भाई उनकी शान में मैं ज़रूर यहाँ पर पढ़ना चाहूँगा। अध्यक्ष महोदय जी, आपसे मैं इजाज़त लूँगा, मान्यवर जी, कि किसी को क्या बताएं कि मजबूर हैं हम, किसी को क्या बताएं कि मजबूर हैं हम, किसी को क्या बताएं कि मजबूर हैं हम, जिनकी मंजिल रहती है हमेशा दूर, जिनके सपने रहते हैं हमेशा चूर चूर, वो कोई और नहीं है साहब, लोगों के शौक पूरे करने वाला मजदूर है, मजदूर है।
The parliament will be continued in the next session.
As my friend had mentioned, that it is between central and state. No, there is a national security board appointed for.
Time is already exceeded. We will conclude on the next session.
Thank you, Granite House. We move on to the next debate, which is by Opal House, represented by Praveen Gandhi College of Law, who will debate on the topic of Industrial Relations Code 2020.